So thank you everyone again for being here today for our workforce webinar series. And I'm going to turn it over to Michael. Thank you, Michael, for being here today.
Well, it's my pleasure, Paige. I always enjoy this topic and working with folks in rural healthcare. If we can have the slides and see if we share our screen. Hopefully everyone can hear us. And let's just start off. So welcome everyone to our topic today, where we're going to be discussing augmenting our rural facilities workforce through the use of foreign healthcare workers. I've been practicing in healthcare immigration for about 25 years. I cut my teeth on healthcare immigration back when most of the rural hospitals and rural health clinics were still independent. So that goes back quite a while. Since then, we've of course seen the expansion of healthcare systems into the rural environment, which has a lot of positive effects as far as increased resources and whatnot. But I still have a lot of institutional memory of a lot of our healthcare facilities when they were independent. And sometimes that helps come into play to craft some legal solutions. I'd like to share some news, some exciting news, at least for me. I know many of our participants today I've probably had the honor of representing in the past, and you will probably recall that I was with the Warner Law Firm for 8 years. And just last month, I changed law firms. I'm now with the Varnum Law Firm, and I made that switch because of the strength of our healthcare department. Previously, throughout the last 25 years, I was always just the only immigration partner in my various law firms, and now I'm the newest of 4. So we have a robust healthcare department as well as a robust immigration department, and we would love to partner with all the participants, come see your facilities, meet with you, never any charge for travel time, and just help you craft solutions to any of your immigration issues, healthcare law issues, HR, or any other legal issues you may have. So with that, let's start today's discussion about how one obtains foreign healthcare workers. So who are the players involved, and why is legal representation usually necessary when a foreign health or a rural healthcare facility needs a foreign worker? As you can see, there are several federal agencies that are involved. We have the U.S. Department of Labor. That's usually the first agency you encounter. They are involved in determining what the prevailing wage would be for a non-immigrant who is going to obtain an H-1B visa. They would also do the same thing if a non-immigrant healthcare worker is going to go for a green card. And next, we would have the U.S. Citizenship and Immigration Services. So after the Department of Labor certifies the appropriate wage, USCIS is the one that would grant visa status to an alien already here, or approve a petition and forward it to the U.S. Department of State. Now, if we have an alien who is in contiguous territories, we say, meaning either Canada or Mexico, they could come in by air, land, or sea, and would encounter at first the U.S. Customs and Border Protection, where they would present their credentials and be admitted into the United States, and the USCIS pre-approved visa status. If the alien is abroad, anywhere else other than contiguous territory, then generally after we've gone through the U.S. Department of Labor and U.S. Citizenship and Immigration Services, that alien would then need to go to a U.S. consulate or embassy abroad and obtain a visa in their passport for the particular visa status in which that alien would enter the United States. And then they may encounter CBP at the airport. Some international airports do abroad have a U.S. Customs and Border Protection office. Others, it would be when they touch down here in the United States. And then lastly, U.S. Immigration and Customs Enforcement. Primarily rural healthcare facilities would have not much interaction with this agency, which is good. But if there were ever an investigation into the legality of the work authorization, or primarily this agency audits I-9s from time to time, although they don't customarily present themselves too often in the healthcare industry. They certainly could if they ever desired to. Usually we would see ICE more in agriculture, food processing, restaurants, those sorts of industries. But those are the major players involved in immigration. They each have their own sets of regulations, and sometimes they all coordinate and sometimes they don't. So it's the job of the immigration attorney to make everything come out right, and so that your foreign healthcare worker shows up on the anticipated start date. So when we talk about how to obtain foreign healthcare workers, there's different classes of occupations where there's different sets of rules. And generally that's going to be for rural healthcare, two sets. You'll have physicians that are their own group in many aspects as far as having separate laws and regulations that pertain to physicians. And then you would have dentists and allied healthcare workers who they have their own sets of laws. But the good thing is that for that group, which is sizable, dentists and allied healthcare workers, it's all the same set of laws for them. So there's just some special exceptions and rules for physicians. One reason for that is because many physicians that are foreign physicians, international medical graduates, come to the United States to engage in GME, graduate medical education. So even though they have a foreign medical degree, they are receiving the exact same training in the United States that a US born physician would receive, that even goes to school here as far as when they go to their residencies and their fellowships. There's two ways for an alien physician to make that jump from attending a foreign medical school or even a US medical school. They would still need a visa, and then entering a residency or a fellowship. Some foreign physicians are lucky enough that their residency programs will start them off on an H-1B visa. And that makes things easier from an immigration perspective, and certainly much faster and much more cost effective from the rural healthcare facilities point of view. That said, a substantial amount, likely the majority of foreign healthcare foreign physicians come to the United States for graduate medical education on a J-1 visa. There's some definite upsides to that and reasons why the various programs favor the J-1 visa. Primarily, there's little to no lawyering necessary to obtain a J-1 visa. That's all handled through the ECFMG, the Educational Commission on Foreign Medical Graduates. And there's a process that's been in place for many decades, and the aliens are able to, run through that process and get their visas and come here to work. So it's efficient, both generally in scope of time, and also there's no legal fees. Whereas with an H-1B visa, generally you would need counsel, an immigration attorney, and also you would pay a substantial amount of filing fees to the US government. So that's the benefit of the J visa. However, the flip side of that is that part and parcel of the J-1 visa is Section 212E of the Immigration and Naturalization Act. And what does that say? That says that an alien physician who comes on a J-1 visa to engage in graduate medical education in the United States, upon completion, must return to their home country for a period of 2 years before they could return to the United States and obtain an H-1B visa, or to obtain a green card. And then there's some other prohibitions as well. However, that provision can be waived, and that's what I engage in throughout the year, every year, is obtaining a waiver of that foreign residence requirement, finding a way for those alien physicians upon graduation from a US residency or fellowship to go straight to work, for example, in a rural healthcare facility. And so there's a process associated with that, and there's 2 ways to do that. And I believe our next slide should discuss that. Let's talk first about what many federally qualified health centers would primarily use, and also other rural facilities, rural health clinics, would be a primary care physician. So how we approach that is through the US Department of Health and Human Services, through HRSA, and they are able to issue waivers. Well, they recommend those waivers to the US Department of State for a particular physician. The US Department of State would in turn recommend that recommendation to USCIS, and USCIS would approve the waiver. So it's a complex process, but one that hasn't changed all that much over the years. Usually there's just some tinkering around the edges, but there's important aspects that we need to be aware of. The positive side is that these waivers are unlimited in number, and they are given throughout the year. So there's no set filing window, and there's no limit on the amount of those visas. So anyone that qualifies can get one. So that is, a fabulous advantage for rural healthcare facilities. But you must be able to qualify. And so there are some restrictions. First, this only applies to traditional primary care. So you have family medicine, internal medicine, pediatrics, OBGYN, and psychiatry. No other specialty, if you will, that may be related to primary care qualifies. And so those physicians need to be practicing in those 5 traditional areas. Also, there's a time limit from the time an alien physician graduates from a residency program to the start date in the employment contract that USDHHS will recognize, and that's a 12-month period. So, for example, many residency programs end on June 30th of a particular year. Let's say it's 2024. So the start date in your contract would have to be prior to June 30th of 2025, or else that physician would not be eligible. So where would that come in as a problem? One example would be, for example, we'll take internal medicine. And let's say an alien physician completes a residency in internal medicine, but then wants to do a one-year sleep medicine fellowship, which is a fairly common scenario. Well, by virtue of that, the sleep medicine fellowships are generally for a one-year period. So if you completed that and then didn't start your employment with the healthcare facility until after that, you would have been more than 1 year past your graduation from your residency. And so you would not qualify for the Department of Health and Human Services waiver. So that's important to remember. That's something we always have to look at, is where is the individual physician in relation to his or her pursuit of graduate medical education. Secondly, and this is usually not a problem in most of Michigan, probably the vast majority of the landmass of Michigan, you have to be in a HPSA with a score of 7 or greater. In the 2 decades and more that I've been doing this, I don't think I ever had a proposed physician come in to an area where the HPSA was less than 7. With federally qualified health centers, they carry their own HPSA score no matter where they go. And I've never seen one with a score of under 7. Also, just most HPSAs in Michigan have scores greater than 7. So that's really not a problem. Recently, though, there's been a development that did not exist in years past, where the USDHHS says, now, if you have a HPSA that's greater than 7, but it's scheduled to be withdrawn, isn't withdrawn yet, but it's scheduled to be in the future, USDHHS will not entertain that HPSA or that waiver for work in that HPSA. So we have to be very careful about that when we're looking up the particular HPSA locale. Also, no medically underserved areas that are not HPSAs. It must be a health professional shortage area as designated. You can't have medically underserved areas or medically underserved populations that are not HPSAs. Now, in contrast to that, we have the Michigan Conrad 30 program. And that program also issues waiver recommendations each year, but there are some important differences, and some of those differences are positive, and some perhaps would be viewed not as generous as the federal program. So, for example, in the Michigan Conrad 30 program, you can have a work site located in a medically underserved area. In fact, you can have a work site located outside of a medically underserved area. Those are called flex locations. So a flex location is a location where usually adjacent to a medically underserved area, but not listed as a HPSA, not listed as a medically underserved area, but the applying healthcare facility can show that it draws 30% or more of its patient base from a medically underserved area. That counts as a flex spot. So those will be entertained by the state of Michigan. Importantly, this is where this program, where we get our specialists. If you recall, under the federal program, only primary care. Here, the state of Michigan will take any physician as long as that physician is either a specialist or as a primary care physician who does not qualify for the federal program. So, for example, you have your internal medicine, to use the previous example, internal medicine physician who took a one-year fellowship after completing residency. And so is going to start outside that 1 year from residency graduation. As we said, that physician won't qualify for the federal program. So you could submit that physician to the state of Michigan, and that would be entertained. Now, the problem is the state of Michigan does not grant waiver recommendations throughout the year. There's only a 2-month filing window that roughly approximates the 1st of September through the 1st of November. I believe generally it's the first business day of September through the first business day of November. But it's just, for our purposes today, just easier to think of it as, September 1 to November 1 for the sake of discussion. Also, another drawback, which is not the state of Michigan's fault, it's the federal statute that set up the Conrad program back in the 1970s. Is that there's only 30 waivers. So you can imagine that there can at times be substantial competition for these waivers. However, it's usually less than people would think, and most people have a pretty decent shot of getting their waivers. It's generally less than 2 in 1 chance. So usually the state has less than 60 applicants that would have a qualified petition submitted. So this, my clients use the Michigan Conrad 30 program every year with a substantial amount of success. So you don't want to, discount that simply because there's only 30 waivers. Now that's bringing us to now other healthcare workers, but I'd like to go back just for a moment to talk about a couple of other significant differences between the federal physician J1 waiver program and the state program. The federal regulations explicitly state, and this goes to our contracting concerns, and throughout my career, beyond just putting these applications together, I always represent the facility, not the physician. I mean, certainly open to entertaining that, but 99% of my career, my client is the healthcare facility. So that means that the physician is just a beneficiary of that relationship that gets to sign on a contract. And so I, as well as my law firm, assist for rural healthcare facilities with their contracting needs. So importantly, we'll see often there will be an issue regarding non-competes in a physician employment agreement. And the federal regulations clearly state that you cannot have a non-compete under the federal J1 waiver program, but the regulations are silent as to non-competes in the state program. The state of Michigan, sometimes in its materials, will say it discourages non-competes, and it could always change. It's a discretionary program. They could prohibit that if they changed their policy. But in general, for many years now, you can have non-competes in the Conrad 30 program. Now, one way around the lack of having a non-compete in the federal program is that we'll do an evergreen contract that will go on for a period of years. It must be at least, both these contracts and both systems have to be at least 3 years in duration, but we can make them what we call evergreen contracts after that. So they roll over year after year. And we simply put a clause in the contracts that if a physician is a J1 waiver physician for the first 3 years, the non-compete cannot be enforced, and that's past muster. So I did want to point that out. Now let's switch gears and talk about all the other healthcare workers a rural healthcare facility might be interested in. So particularly in rural health clinics and our FQHCs, there's almost always a dental program accompanied also with behavioral health. And then in varieties after that. And you could have small rural hospitals, even though they're part of the greater healthcare system, would have need for physical therapists, med techs in the hospitals, could be occupational therapists from time to time, that sort of thing. The rules for those folks, the dentists and the allied healthcare, are pretty much all the same. Now, generally, there's always a question of, well, how do I come by these professionals in the first place, and how do I get them to work for my facility? Well, that is generally a challenge, but oftentimes we will find that these foreign healthcare workers are already in the United States, and they're here on an F visa, which is a student visa. So the difference between because one might ask, well, why does a physician have to be on a J visa and have this 2-year foreign residence requirement when that doesn't pertain to a student visa? Well, the reason is that the J visa, even though these foreign physicians are extremely skilled individuals, it's considered a trainee visa because they are undergoing graduate medical education, which is academic in conjunction with hands-on training. And of course, residents are paid for their work. Severely underpaid perhaps, but they are paid for their work. And so they have to have a visa that allows for both training and payment. And the J visa is designed specifically for that in the GME context. Now, F1 visas, the ability to be employed is extremely limited during the course of studies. However, once a foreign student graduates, let's say they went to dental school on an F1 or a physical therapy program, they're going to graduate and be offered what we call OPT, which is known as optional practical training. And what that is a 1-year grant of work authorization where the alien can work for any employer as long as the employment is associated with the course of study. So a dentist is going to work in dentistry, a physical therapist is going to work in physical therapy, a med tech is going to work in a hospital laboratory. So that's pretty straightforward. One benefit of this is that it, again, like the J visa, that needs no lawyering to obtain the J visa. Likewise, the F1 visa almost never requires any lawyering to get that visa. The proposed students are able to navigate that process. And then once they get close to graduation, in conjunction with their university, college or university's international student department, with those personnel, they're able to, if the student is proactive, able to apply easily for what's called an employment authorization document. And that does result in a card that looks like a little driver's license, good for a period of at least 1 year. And it allows the foreign healthcare worker to work. Now, why is that important? Well, that gives us time then to apply for an H-1B visa for the foreign healthcare worker, which then allows them to work, in addition to the 1 year, at least 6 years. The maximum period of stay for an H-1B visa is 6 years. And then that allows the foreign healthcare worker to have enough time in conjunction with the employer to pursue a green card, to pursue what we call permanent residency. So you have the ability to keep someone on staff if both parties agree for many, many years. The H-1B visa is extremely common, and it's for workers that have at a minimum a bachelor's degree in a specific field. And of course, with dentistry, that would be a doctoral degree. Physical therapy, years past, would have been a master's degree. You could have a bachelor's of science in nursing that would qualify, although there's many restrictions on nurses as opposed to the other worker categories. So the H-1B is a fairly common visa for healthcare workers, and it's an excellent one to allow you time to get them outside the immigration system once permanent residency is granted, if that's started soon enough. However, one aspect of the H-1B visa needs to be thought through, and that's that most H-1B visas are issued on a lottery quota system. So there'll only be, say, 85,000 for the entire United States, and they're issued usually around April 1st in a lottery, and it's maybe a 5-in-1 chance. I've heard 7-in-1 chance. Used to be 4-in-1 chance of being selected. So those are pretty terrible odds. However, what we've found is that that works well for our foreign, our rural healthcare facility clients, is that there's an exemption from the lottery, and that exemption from H-1Bs, meaning you can get an H-1B as many as you want any time of the year. And that is an exemption that applies to nonprofit institutions that are affiliated in some way with a college or university. And we've had many, many clients that have thought, well, we're too small of an institution to make this work. But working together, we've been able to assist smaller healthcare providers to develop a relationship. It can even be with a community college, where if we have in some respect any students entering the healthcare facility for any type of educational purpose, and if we have an agreement reduced to writing about that relationship, which generally the institutions of higher education already have, then we can make that work and get H-1B visas. So we've been very successful over the years in helping folks get foreign healthcare providers when they can't get enough US workers to develop these relationships and qualify for H-1Bs. We've had a lot of success for that, and so we would never want our providing facilities to discount that. Another way to get foreign healthcare workers that's really a very efficient and cost-effective way, it's fast in time, reduced legal fees, would be to go under the former NAFTA agreement. And that agreement now is referred to as the USMCA, the United States, Mexico, Canada agreement. That had been reworked in some provisions, but NAFTA, which came into force in the 1990s, the immigration provisions with the new agreement remain exactly the same. So it's important to realize that this only applies to citizens of Canada and Mexico. But if you can, and now you can have multiple citizenships and that's fine. But if you can demonstrate, no matter how many citizenships an alien may have, if you're Canadian or Mexican by virtue of citizenship, not by birth, but by citizenship, that's sufficient to take advantage of this treaty. And Canadians have a different process than Mexicans. For the Canadians, their process is much more efficient. They don't have to apply for a visa whatsoever. As long as they have their Canadian citizenship, proof of their healthcare credentials, any required certifications, we can just with a letter from the employer and those other pieces of evidence that I mentioned, bring these folks across in one day. The same day they apply, they can enter, and that entry will be granted usually for a 3-year period, as long as their passport's also valid for 3 years. And that status can then be extended for an additional 3-year period, and there's no limitation on the number of extensions. So if you look, and these folks can work anywhere within the state of Michigan, but prime examples are our ports of entry. So we're thinking Detroit, Port Huron, Sault Ste. Marie. You will see healthcare workers living in Canada, but streaming across the border lawfully on a daily basis, Monday through Friday to work. This works for a lot of nurses, specifically in the Metro Detroit area, but throughout Port Huron and Sault Ste. Marie. But as I said, that's just a convenience for some folks that don't want to give up their domicile in Canada. They want to work within commuting distances, but anyone that is Canadian or Mexican that wants to work anywhere in Michigan and is in the right capacity as far as their occupation can certainly work anywhere in Michigan for 10, 20 years or longer. As I say, there's no limit on the number of 3-year extensions. And beyond what we have here on the slide, we see this works for dentists. This works great for registered nurses, pharmacists, dietitians, nutritionists, social workers. It also works for physical therapists, psychologists, and medical technologists. Would also work for occupational and recreational health therapists. So that's a visa status that should not be overlooked. With Mexicans, it works identically. However, they simply need to apply for a TN visa. That's the visa status, is still Treaty NAFTA, even though they've changed the name of the agreement, the visa has not changed. They simply apply for a TN visa through the U.S. embassy or one of the consulates, U.S. consulates in Mexico, get their visa and then come across. So the process takes a little bit longer. There's a little bit more expense involved, but as long as the credentials are legitimate, really, there's very favorable outcomes to be anticipated as far as getting a visa and getting your worker. One thing we can talk about, because many facilities are, of course, well, it would be rural healthcare hospitals primarily interested in nurses. The H-1B program for nurses does not work well. And as I mentioned before, of course, the H-1B is for advanced degrees or bachelor's degrees, and we can have a bachelor's of science in nursing. However, the occupation must be one that cannot be fulfilled by someone with a lesser degree. So of course we could have registered nurses that have associate's degrees. And so USCIS will not grant an H-1B visa for a nurse with a bachelor's degree, except in nursing manager positions or for advanced practice nurses, CRNAs, and those types of advanced practice nursing positions. So really for nurses, you're going to be confined to, the TN visa. Now there are options for other aliens outside of Mexico or Canada, but there's no good non-immigrant visa for them. So in general, you have to apply straight for the green card. And the problem for that is that it's a multiple year process to do that. The upside is that you can get nursing assistants, you can get licensed practical nurses, any nursing occupation. You simply must first go through the Department of Labor for anything other than a registered nurse to show that there's a shortage in that area. Registered nurses and physical therapists, the U.S. Department of Labor has predetermined that there's a shortage available, so you can skip a lot of that process. So that's basically a lot of law in a little bit. And I recognize that. Hopefully you'll have some questions for me. But I did want to point out, when don't you need to worry about immigration with a foreign healthcare worker? They're not Americans, but they have work authorization that doesn't require any additional filings. That would be, you can have a green card holder, a U.S. permanent resident. They have the lifetime right to remain in the United States and work here. You I-9 them one time, and then they're good to go. There's also folks from troubled spots in the world, say, for example, Haiti, others. It could be the Ukraine, that are temporary protected status. Those folks are already work authorized. We have asylees and refugees that come from war-torn areas of the world. They're granted work authorization already when they come here. So nothing more to do with those folks. If you happen to run across them, those are fairly rare examples as far as the TPS and the asylees and the refugees. But it's very easy. If you ever have any questions, our office is available to guide you through that, and it should be a simple process. The one thing to know, though, is that they still must, of course, meet all the state of Michigan requirements for a healthcare worker. And I think now we're up to the question and answers period. I don't know if we have anything in the chat page.
Yeah,
Oh, did I go? I'm going to go back to here.
So we do have one raised hand from Scott. Let me think you can get off mute, Scott, if you want to ask your question here.
Hi, can you hear me okay?
I can hear you perfectly.
Awesome. I'm Scott Blix. I'm the Chief Nursing Officer for Schoolcraft Memorial Hospital. Appreciate your time.
Nice to meet you.
And,
sure, nice to meet you.
I guess my question, my understanding, what I just heard was the best way to go about this is the USMCA agreement for the registered nurses. We are close to Canada. I do have just recently started attending Sioux Canada College, talking to the nursing program there, seeing what we could do to recruit. So excellent. My understanding is we could possibly get a one day turnaround on them, as long as they're a citizen, correct? A Canadian citizen. We could get them across the border to work for us in one day. I guess, how do we go about that process, or who would we talk to?
Well, you talk to me and I'd be delighted to assist you. The one thing we have to keep in mind, what you would need in advance of that is all the nursing credentials necessary to start the job on day one. The alien nurse needs that. So anything that the state of Michigan requires, that we need in advance. Then to take benefit of the treaty. And if they're Canadian, how that works is we would, assemble the credentials. in conjunction with you and the foreign nurse. And then we would provide a letter on your letterhead. I think the visa, the status application fee at the border is still $56. I would have to double check that. So it's amazingly a very minor amount of money. But yeah, and then that is a same day entry. They present the letter and their credentials along with their passport, which proves their Canadian citizenship. And then they come on in for 3 years. And we would, of course, work with you to make sure that everything is ready to go ahead of time. But yes, that's textbook example of an easy way to do it.
Okay, great. My second question would be other areas that are difficult to recruitment, such as physical therapy, respiratory therapy. Does that apply similarly to the RNs, or is that a different process?
No, that can be a similar process as well. You know, if they're Canadian or Mexican. However, with those occupations, you also have the added ability to go for an H-1B visa as well. So depending on the situation, we would sort out with you which is the best route to go.
Okay.
So it's the problem is that the immigration regulations years ago were really ratcheted down against nursing because there was not, and I mean, this goes way back, probably to the 70s, maybe 80s, where there wasn't a nursing shortage, and then they've never been updated. So that sort of not prejudice, if you will, but obstacles that exist for nursing in the H-1B system exist. There used to be an H-1C that applied to nursing. There still is some H avenues for them, but generally the way the statute and regs are written, it's only you know, like the larger health, you know, university hospitals that can avail themselves of that. And even then it's restricted. But yeah, we could definitely, we'd be delighted to assist you.
Thank you, Michael. Appreciate it.
My pleasure. Any other questions?
Yes, so feel free to put it in the Q&A in the chat or raise your hand. Sean has, can you give a rundown on costs for visas?
Oh, I know Sean. Hello, Sean, how have you been? Is he
some of them are I can't get Sean to talk, but some of them have to be allowed to talk.
Oh,
but yeah,
okay.
he just put it in the chat there.
All right.
So, but yep, he's here right now.
Right. Well, so costs, you know, depend on the visa that's being pursued and the aliens, where they are in the immigration process, if they're already here in the United States. For example, J1 waivers are fairly complex, and you're going to see you know, substantial fees involved with that in conjunction with an H-1B visa, which you also need to get work authorization. So those are, you know, well in excess of $10,000. Now with a TN visa, let's say for a dentist, you could be looking at $1,500. So it just depends on the exact scenario that you're confronting and how much lawyering time and how many federal agencies we have to work through to get the alien, whether they're already here in the United States or they need a visa from abroad. So I would say, if anyone has a question on fees, you know, we would certainly be happy to quote you in advance. And once we know what your exact situation is, you just simply call the office. And I would also point out too, if you identify, and perhaps Paige will give me a list of the folks that participated today. If you do identify yourself as having participated, I've done this for years. You know, I'm happy to give you a free consultation if you were part of this webinar. I think that's always a great way to thank people for participating, and gets us together, so it works out well for everyone.
Sounds great, I think. And then Sherry said, can you please provide Michael's contact information again for us to reach out in case we have any viable candidates that he could assist us with? Yes, I will.
And I also have a slide on that. If we were to share the screen again,
yes,
we could put
that back up. But I will send out to everyone as well.
I think it's the last slide.
I will send out the slides
there we are.
Probably tomorrow morning to everyone who's participated and registered, along with the recording as well, so you can refer back. But yes, there's Michael's contact information if you'd like to write it down now. But like I said, I will be sending all this out to everyone who registered and is in attendance today. Let me see if there's any. Oh, that's Sherry's. Any more questions, you can raise your hand or put it in the chat. I know we're coming up on 1 p.m., but if there's any more, it looks like. Is there any countries that can take longer to get a visa?
Yes, if the alien, and are we on mute or is it?
Nope.
Oh, we're good. Okay,
yeah.
great. Sorry about
No.
that. Old man syndrome.
Okay.
Yes. The answer is yes, and it depends. I wouldn't necessarily discount an alien simply because they come from a country where that might be an issue. Where you find delays in visa processing will be either there's unrest in that area of the world, or that particular post has experienced a high degree of immigration fraud, and so they look more closely at their applicants. That varies over time, and workloads change over time. What we're able to do, if there is a visa application, if the alien's not already here, because then we don't have to worry about visa processing if they're already here in GME or, you know, studying at the bachelor's degree level. We're able to access the electronic calendars of every consulate in the world once a visa application has been submitted, and then we can get an idea of how long that's going to take and inform you. And then we have a few tricks up our sleeve as far as, if it's a matter of urgency, we can put paralegals and other support staff to access that calendar on a daily basis, sometimes at least twice a day, and appointments pop up. You know, somebody gets canceled, somebody gets sick, and we're able to take advantage of those. So it's a difficult question to say, oh yeah, you know, India is going to be terrible. That's not necessarily the case. It depends on the country and what's happening at that point in time. And again, we can help you with that.
Don't see any in the chat. And I think, Scott, that's probably an old hand. Or do you have any more questions?
Oh yeah,
Scott?
I'm sorry.
No, it's okay. Just wanted to make sure.
And lower it. There you go.
Let me see if there's any in the chat. Give it. Any more questions for Michael before we log off? And not, again, you can always feel free to email him. And like I said, these slides will be available in the recording, and reach out to him with any questions you might have in the future too. But with not seeing any more in the chat.
And then if I may, I'd just like to say, and if I could go back to the slides just real quick, if we got a couple of minutes, if folks are still left. Why can't I get that to move? There we go. I just wanted to speak a bit about our law firm and the services that we can offer you. We're one of the largest law firms in the state of Michigan. There's 180 plus lawyers. We have as I said initially, just a great healthcare law department and a fabulous immigration department. You know, we're 4 partners in immigration, which is extraordinary in Michigan. And we have 3 associates, we have support staff. We handle all types of immigration, manufacturing, IT, all of that. And I can as well, but as I said, I started out in healthcare over 25 years ago, and it's my passion. I've been practicing it ever since. So whatever anyone's healthcare need is in immigration, we can take care of it. You'd generally be dealing with me at the strategy phase for sure, and all the way through if you so desire. But this is just a great law firm. I'm happy to be a partner of it, just exceptionally proud. We're rolling in immigration. We look forward to helping you.
Sounds great. Well, there's no more questions here. Just make sure. Well, thank you everyone for attending today, and be on the lookout tomorrow for the recording and the slides, but feel free to email Michael if you have any more questions in the future. But thank you for attending today, everyone.
Thank you.